Friends, now we look at the Torts essay question from the February 2011 California Bar Exam. One note about something I intend to do with this question. I'm going to publish it on our website just like I have the other fact patterns. But I'm going to do one thing a little different. I'll post my law professor model answer, but I'm also going to post the 2 example passing answers that the California Bar released for this question. And I want you to have a look at them for a couple of reasons. Mostly so you can have a look at what a realistic passing answer looks like. A law professor answer, by its nature, is somewhat artificial, even though I write my initial draft in under an hour. I've been at this a very long time. And if you look at my answers in a vacuum, you might think, do I have to practice law 30 years before I can write a passing answer? Certainly not. And when you look at the example answers that I give you, I want you to look at my answer critically. Just because I wrote it and I think I'm a nice guy and a pretty talented professor doesn't mean the answer is all that good. They're all credible. A lot of them have been published. But it's just another written product, just like, an ad in the newspaper or a story in a book. And I want you to understand what the examiners are looking for. My answer will help you do that. But comparing it and contrasting it to a couple of quote-unquote real answers that we're passing can be useful too. Because one thing it will show you is almost none of the published answers are as rigorously organized as mine are. Some are, but by and large not. So if you're at all intimidated by the rigor at which I organize my answers, you can probably learn from it, but also you don't have to be too concerned about reaching that standard. Okay, anytime somebody gives you a fact pattern on a bar exam or a law school exam, you should always go to the call of the question first and see if you can outline it. So question 1 asks, under what theory or theories, which means come up with as many as you can, might Paula bring an action for damages? That tells us this is not a remedies question. If it was a remedies question, the language would be more like, what remedies would she be entitled to? Or what claims and what relief would she be entitled to? This question's only asking us about damages. Now, it might be a really complicated damages question. It turns out that it isn't. Some are. But the reason for looking at this language closely is to know you're not worried about the whole remedies outline. You're worried about either torts or contracts or maybe property until you read the facts. So we've got 3 lawsuits in the first question. Actually, in my model answer, these are A, B, and C rather than being separated. Roman numerals. Either way is basically acceptable. We're trying to spot as many theories of liability as we can, and the only remedy we're concerned about is damages. We're not worried about restitution. We're not worried about all the different types of equitable relief. Then question 2, which is Roman numeral 4 on the chalkboard, on the whiteboard, is Harry versus all 3 defendants. I list them here for our purposes. We could graph it straight down, but might as well make it at least vaguely visible. So after having looked at the call of the question and outlined it pretty carefully, then we go to the top of the question. Gail, who is our first defendant, is 16 years old. Okay, stop right there. What's this question about? Almost certainly torts. Why do they tell you what her age is? Either because she may or may not be capable of entering into a contract, but almost certainly they're telling you her age because she's going to be a defendant in a negligence action. Almost for sure. Okay, look at paragraph 2. One day, Gail's teacher was relaxing in the teacher's lounge during the first 10 minutes of class time, as he usually did, leaving the students unsupervised. School district, our third defendant, had long been aware of the teacher's practice, but had done nothing about it. Okay, well, we know the school district is going to be sued for negligence for something. And that the fact that will give rise to the claim will be their knowledge of the teacher's misconduct and their failure to act. Paragraph 3. That day, where the teacher's in the lounge, back in my day in high school, the teachers were smoking in the lounge. Sadly, or happily, no longer the case. So, teacher's gone. Gail walks out of class and out of school. got into her car and drove to the house of an adult friend, Francis, who is defendant number 2. Gail had promised Francis that for $10 she would help her move some paintings. Paragraph 3. Arriving at Francis's house, Gail carelessly parked her car several feet from the curb and entered the house. So you stop right there and you think, okay, there's the negligence. Okay, but it's a red herring. That's not really the act of carelessness that gives rise to the cause of action. She came out later, carrying paintings to her car. In a patrol vehicle, Paula, a police officer, spotted Gail's car. Okay, well, Paula's our lead plaintiff. So Officer Paula is going to be suing Gail and Francis and the school district. We don't yet know what she's suing Gail for, but we know she's going to be, and we don't really know what she's suing Francis for yet either. But whatever bad thing happens, the school district will be liable, according to Paula, for not supervising this kid well enough. Francis caught sight of the patrol vehicle and told Gail, so grown-up speaking to child, quick, move your car to the curb. Now, as far as I can tell, that's the only thing Francis does in this whole question. All right. Next, Gail jumped into her car just as Paula was walking towards it. Suddenly, without looking, Gail swung her car toward the curb, hitting and severely injuring Paula. Okay, so now we've got all the facts we need for Paula. Paula versus Gail. 2 theories of liability. What are they? Don't all answer at once. Harmful intentional touching? Maybe. Battery. And she isn't even looking where she's going, so negligence. I list battery first because it's an intentional tort, but the negligence issue is really the more complicated one. So it might be appropriate to put negligence first in the real answer, which in fact is what I do. But we know that negligence breaks down into duty, breach, causation, which is more complicated than we currently study, then damages, and I always add for analysis, defenses. Then finally, the very last paragraph. We haven't heard anything about Harry, and now we do. After Paula was transported to a hospital, she was visited by her husband. Husbands are typically named Harry, also on community property questions. Wives are usually called Wilma, but we'll leave that to the side. Shocked at Paula's condition, Harry collapsed and suffered a broken arm in the fall. And we don't know anything else about Harry. We know that Paula is young enough to be an active duty police officer working traffic. We assume her husband is not old enough to be her dad, but we don't know. So then we get the call of the question, under what theory or theories, if any, might Paula bring an action for damages against the 3 defendants? And then we get Harry's theories of liability. Now realistically, it's very hard to break all 6 causes of action, all 6 lawsuits, up into tiny fragments. Up to some extent you can do it. But let's consider the issues in somewhat greater depth. We've got Paula, an on-duty police officer who's seriously hurt when Gail hits her with a car. She will sue Gail, Francis, and the school district for damages. Her lead claim against Gail is negligence. All we have to do as far as a rule is concerned here is basically just state what negligence is. If Paula's going to prevail, she's going to have to show that Gail breached a duty that was owed to her, causing damages. Putting a more academic definition in, I don't think really does us a lot of good. Okay, duty. Here we get into that little detail about her age. She's 16 years old, but driving a car is an adult activity, so she'll be held to a reasonable adult standard of care in so doing. Okay, she committed 2 different negligent acts. First, she parked her car a few feet away from the curb. I put that down because I want to find a home for that fact, and this is where it goes. But that first act, although careless, didn't cause any damages. It's worth explaining that. Her second negligent act was to suddenly move that car without even looking where she's going. Reasonable drivers of any age don't make sudden moves without looking where they're going, unless there's some serious emergency, right? We looked at emergency cases. If you need to change lanes suddenly, you might have a defense. But here, Defendant Gale was feeling a little bit of an emergency. But being worried about getting a parking ticket is not the sort of emergency that allows a person to act with less care than would be reasonable in an ordinary circumstance. Now, the causation issue here is fairly simple because but for Gale's carelessness, this accident would not have occurred. And the facts are not complicated enough to give any more complicated causation issues. The problem that this question presents is writing a thorough answer with all the analysis under time constraints. With regard to damages, all we have to write is that Paula suffered severe physical harm, and she's obviously going to suffer a lot of associated pain and suffering, and probably significant financial expense, or potential significant financial expense and treatment also. Now, can anybody think of a defense for Gale? We haven't really gotten into defenses to negligence yet, but really, her only possible defense to a negligence claim is that the officer somehow carelessly walked into the street and there's no facts to support it. So I mention this possible defense just to show that I'm straining to think about what the other argument would be. This teenage driver messed up, and she doesn't really have many defenses. Okay, I take it a step further. Not only do I consider battery and negligence, but I throw in a little bit on recklessness. This conduct probably isn't that severe, but it does look a little bit more like something more than ordinary negligence to me. Maybe not to you. But in order for the plaintiff to win on a recklessness theory, we'll cover that theory in a future session, what the plaintiff has to show is that Defendant Gale had a wanton and willful disregard for life. And I don't think they can show that. She's just trying to park her car. It wasn't like she was driving drunk way over the speed limit on the wrong side of the street. Then we go to battery, and the plaintiff actually has some proof problems here. It's obvious that Gale didn't intend to hit this car. She did not have the intent required for battery. Battery is a specific intent tort. I'm mixing from crimes, but you've got to deliberately do it. You can't carelessly do it. And if you do, in fact, carelessly hit someone, that's negligence. It's not battery because of the transition in the law. So the conclusion that I reach is Paula will obtain compensatory damages, but not punitive damages, because the only viable theory of liability that I show is negligence. Now, suppose you do the analysis and you come out differently on recklessness. Suppose you look at this and you just say, you know, that's just totally unreasonable. It's not mere negligence, it's actually recklessness. Okay. What the implication of that conclusion is that the plaintiff gets punitive damages too. So anytime they're asking about damages in torts, you should think compensatory and punitive. But remember, the plaintiff only can recover punitive damages when the plaintiff has established intentional wrongdoing on the part of the defendant. Okay, now we get to the next lawsuit, Paula versus Francis. We have very, very thin facts there. But I would suggest that Francis obviously has a duty of reasonable care. All we know about Francis is that she saw the badly parked car, she saw the police officer, and she said, "Quick, move your car to the curb." I quote the language directly. Then we have to ask and answer the question, is it reasonable for one friend to tell another friend to reparked their car under the circumstances. I look at the facts, and maybe I'm just a defense lawyer, but I don't see Frances having done anything that falls below a reasonable standard of care. Now, one way that you might make the argument would be to say, Frances is an adult, she's supervising a child, and thus has a duty to give a more clear instruction. Fair enough. If you reach that conclusion, that's reasonable. My conclusion is no negligence, therefore no liability. If you conclude differently, you reasonably could. Compensatory damages only, no punitive damages available. Then we consider Paula versus negligence. Now, at this point in my analysis, I collapse it down. I talk about duty and breach in one paragraph, causation and damages, and defenses, all in another paragraph. These are so thin that to spread them out makes it look a little silly, and it's easier under time constraints to get into it in a more narrative fashion. Okay, what do we know about the school district? Well, we know that Gail left her classroom because she was unsupervised, because the teachers in the lounge and the district knew about it. So what the district did, in fact, was failing to act. It had long been aware that the teacher was sloppy and lazy and not doing their job, and the school district owes a duty as a substitute parent to take care of this girl and keep her in class. And respondent superior is the principle that allows us to go after the school district for the teacher's negligence. Okay, how about causation, damages, and defenses? Well, this is the easiest action of all. Causation is very clear-cut. It is possible that the defendant could make a chain of causation argument. Hold that. We'll talk about causation at great length in the not-too-distant future. But it's apparent to me that the school district doesn't really have any viable defenses. Paula suffered these injuries because the school district didn't do their job. They're on the hook for compensatory damages. Again, no punitive damages. Then, finally, we turn to Harry's action for damages. Now, I suggest that it's foreseeable to any driver that car crashes can also injure people who are not physically injured in the accident. So, Harry is entitled to damages from Gail for loss of consortium. That's a harm that we will study in the future. But loss of consortium doesn't mean only lack of sex. It means lack of companionship also. Loss of consortium, the loss of companionship. Now, he will be able to recover for that. What about his broken arm? It's true that but for Gail's negligence, he wouldn't have been hurt. But he wasn't anywhere close to the accident. And it happened a long time later. So it's not like he was in the zone of danger and actually saw his wife get injured. So it is very unlikely that he's going to recover damages for his broken arm, although he could for loss of consortium. How about Harry versus Frances? Well, I've already concluded that Paula is unlikely to be liable to Frances. If you agree with that, then the claim of Harry against her is even more thin. If you conclude that Frances improperly supervised a minor under her care, it's a somewhat closer call. How about Harry versus the school district? Well, he's got a valid cause of action for loss of consortium, and it's basically, analytically, Harry's action against the district is the same as his action against Gail. So the bottom line conclusion as to Harry is that he'll win loss of consortium damages both from Gail and from school district, and none of the defendants will face legal liability for his broken arm. That's the end of class. I've been delighted to share these last several hours with you, and already I'm looking forward to next week, where we will get even deeper into negligence. Thanks for joining me, and good night.